Hey everyone, it is RobbRyder on Monday, February 9th, 2015. And on 1/30/2015, notice to appear issued to Sandy Wegman was entered into a court case in Illinois, which is 2013 CM 003431, disorderly conduct. Kane County Circuit Court, Circuit Clerk. And as it turns out, in Illinois, a notice to appear is like you've been arrested, you need to show up to court. All right, it's a subpoena. So if she doesn't appear, it doesn't say it's a subpoena, but for all intents and purposes, you don't appear, they can come arrest you. It's a subpoena, and she needs to be there for a bench trial at 12:45, room KBC, in front of Judge Teague Eller. But as it turns out, 2 days before that, Roe had a hearing, and it was also continued to March 18th, 2015 at 1 p.m. So 15 minutes after Sandy Wegman is supposed to appear for a bench trial, Roe's supposed to appear for a hearing, and it's actually a discharge hearing, and where all these players fit in have been talked about in previous videos, but in a nutshell, Sandy is the county recorder who back in August of 2013, because Roe was asking, really just asking too many questions, peacefully, very peacefully, but, the clerk didn't want to have to try to answer questions like, well, why you charge me this much when the statute says to charge me this much? That she filed a complaint for disorderly conduct against Roe, and come to find out over time that it was never ever really being prosecuted as a criminal case. It's always been civil, because they took Roe in handcuffs to a holding area and said she could leave as soon as she signed a release form of some kind, or whatever the hell they called it. And on it was a block called the Certificate of Defendant, and by signing that block, you agreed that you were the defendant, who was your last name, comma, first name, as the defendant, and that you owed some entity. I can't remember if it was the people of Illinois or exactly what the words were, but it wasn't the government. It was, some other entity, $1,500. Well, that's what they're going to charge you with from there. Is now we're going to keep it civil and collect on the $1,500 and not turn in the criminal complaint for a crime, disorderly conduct, which in the next city over from where Roe is, as an ordinance violation, is a $35 fine. So we're not going to charge you the $35 fine. We're going to get you for $1,500. That's the game they play. So anyways, somebody had to start it, and Sandy's the one who filed the complaint. And the complaint's bogus, and it doesn't have the proper notary seal on it. And we've pointed all this stuff out in different ways to different agencies, and nothing's really happened. But just here, so it's here, something has happened. Notice to appear. That's the same as getting a ticket. She has to appear. And so Roe will have to be there also at 1 o'clock. And so this looks like one of those situations where Handcuffed John's son, it had happened to him where they had put paperwork in, and the prosecutor met him outside the hallway. And I've heard of this happen to other people before, where the prosecutor meets them outside the hallway and they want to cut a deal and da-da-da-da-da, right? And they don't want you to get in the courtroom. Well, the reason for that is the guilty party is already in the courtroom, right? Sandy Wegman will already be there. She had to be there at 1:45 or 12:45. And so Roe's going to have a discharge hearing, and in a discharge hearing, the prosecution has to bring forward their evidence, and based on the evidence, if there isn't evidence, well then the defendant is acquitted. And there isn't any evidence. And actually, we kind of know this now because as it worked out last week, Patrick in Arizona, his mother was talking to somebody at the clerk's office about how come our paperwork isn't seen in court, like a real simple question. And the lady said, well, you need to go see the exhibit clerk if you want the judge to see your paperwork. Oh, how come the judge doesn't see our paperwork? Act like he doesn't see our paperwork. Well, you need to go see the exhibit clerk if you have paperwork you want the judge to see. Like we should know this stuff. Well, of course, I don't know anybody who goes to the exhibit clerk first, but it makes sense that you should, and I've done some videos that touched on that, where in Michigan you're supposed to go to this other clerk before you go to the court clerk, and they call it the county clerk, lowercase county clerk. And there's been evidence of this happening where a guy had a court case and his attorney went to one office and then to another office. He took paper to two offices, basically. One of them being the court, the other one being to do with the county. So yeah, there is a thing that you may need to go see an evidence judge or an evidence clerk. But so where are we now? Anyway, so if we go back, so she had this hearing, and they don't have any evidence because Roe went to talk. So once we found this out from Patrick, I mentioned it to Roe, and she had to go to look at her court file anyways, and we're going to look at what she found here in just a second, and asked to see the exhibit clerk. So she just went to the clerk's window and asked to see the exhibit clerk, and they went and got her. No big deal. If you want to see, if you need to know who the exhibit clerk is, go and ask them, because apparently they'll tell you. And Roe asked if there were any exhibits in her court case. And she gave the lady the number. She went and looked, said, no, there's not any. And she said, well, I need to go look at one other place. And she went to wherever this other place is. And no, there wasn't any there either. So there isn't any evidence in the court case, not for Roe, nor for the prosecutor. They don't have any evidence. And Roe's evidence is things that she's already done that we're going to see about getting into evidence, where we've pointed things out, and in fact the judges have put the paperwork into the court case. And we're going to look at that stuff in just a second. So where did that happen at? Right here on the 8th, where it says Judge Novarini, right? Notice of mandatory judicial notice filed and proof of service filed with the judge's name, like the judge did it. But what we had done is we had mailed it to the chief judge and to the public defender. And then went and filed it in the court case. And when Roe first filed it in the court case, they just called it a correspondence. And she had to call them a couple, 2, 3 times. Well, eventually it changed to have these names where it said notice of mandatory judicial notice and proof of service. But on the normal page you look at, you don't see who put these in unless you look at the expanded page, right? And they have a little button. If you don't click it, you don't even know it's there. But if you do click it, boom, you get a little more expanded information. And this tells you who put it in. So they said that the judge put it in. Well, this isn't the chief judge, right? So the chief judge gave it to this judge, who filed it into the court case on the 8th. And we're going to look at what it had to say. But since then, now there's a bench trial set. And in between, there was a notice, another notice filed by another judge. So judges are putting all sorts of paperwork in this. And they issued Roe a bond check, refund, for a partial refund of her bond. And, when we look at this paperwork, it's going to blow you away. So that's really what this is about, is just looking at things that had to do with this court case, that by doing the things we're doing, we get to look at paperwork that isn't necessarily seen very often, or things that don't happen very often. But Sandy Wegman, who filed a claim against Roe, now has to come to the same court case that court that initiated back in 2013 as a defendant, because a notice to appear in Illinois is the same as getting a ticket, getting a citation. So, and then there's been a criminal subpoena that's been issued in here. We're going to take a look at it. So, okay, that's enough of that. Oh, there it is. Criminal subpoena, return filed. Let's look at that first. Let's take a look at the subpoena. Okay. Now start paying attention to the names. It's the name game. See, the plaintiff is the people of the state of Illinois. Defendant, Rosita Straskovine. Most times they don't have her name in that particular order. Usually it's surname, comma, given name. And this is in the circuit court for the 16th Judicial Circuit. We have a forecourt and an in-court. This is the forecourt. It's the misdemeanor traffic division. And in Roe's court case, there's paperwork for the forecourt and the in-court. Two different court cases running in the same file. But this says, so the plaintiff is people of the state of Illinois. This says case number something criminal subpoena. The people of the state of Illinois hereby command your presence. Greetings. And this was to the psychologist that was supposed to be there. To testify under oath as a witness for the people of the state of Illinois, not people of the state of Illinois. People of the state of Illinois is not the state government. It's going to be the name that they're hiding behind in this fictitious entity they have, but it's not the state government. If the state is bringing the charge, it's the people of the state of Illinois, not people of the state of Illinois. So this is supposed to be a criminal case for Roe, right? This one we're looking at here is a criminal division because it is in the name of the people of the state of Illinois. And so, yeah, he had to show up, and if he didn't show up, he could have gone to jail, and he had to be there at 12:45 also. Now, on this day when he had to show up, Rose had, guess what? She had a court date the same day, and she had to be there at 1 o'clock. Well, the doctor didn't show up until after 1. Yet this is supposed to have been, I think, in the same room, Kane County. Room KBC for a bench trial, 12:45 bench trial. Roe wasn't there at 12:45, but I bet you the public defender was. So something was worked out, because we already had some pretty strong paperwork in, and we had told them to take judicial notice by this point. In fact, that was just the one before. Let's take a look here. Because this is when the subpoena was, on the 12th. That's when it was filed. So it was returned for a hearing that was going to be on the 13th. And we had put this in on the 8th, this notice of mandatory judgment. So what we told them then was, give me just a second. Okay, so we filed this in on the 8th. This is what got put in the court case. It was called mandatory judicial notice. And really, when it was filed, it would be just like doing it as a notice, but the other party that was being served was the chief judge of the 16th Judicial Circuit and the public defender's office. Okay, so Chief Judge Brokaw, judicial officers of the Court of Illinois, I, Rosita Straskovine, in proper persona, you want to be seen your proper person, defend my interest in this matter by invoking mandatory judicial notice of the adjudicative facts and law. Right? And that's what judicial notice is all about. By the rules of evidence, if you don't tell them to take judicial notice of the evidence, they don't have to look at it. That's all we're doing. We're going to make them take judicial notice of the adjudicated facts. Well, that's the evidence in the court case. And then whatever the law says about the evidence. So take judicial notice that the judicial officers involved in this matter have not appeared in their official capacity in violation of Illinois Supreme Court rules and Illinois public laws. Stay real general, right? It is a violation of the Illinois Supreme Court rules, and it is a violation of Illinois public laws. I don't need to tell them which one it is. It is. They'd have to call me a liar. Well, if that's the case, then I'll go find the damn thing and show them where it says it. But, take my word for it. It does say it. Make them rebut your presumption. So take judicial notice that a written instrument already filed for the plaintiff by its attorney in this matter, Exhibit A, complaint, Exhibit B, bail bond form, Exhibit C, arrest warrant. These are the three pieces of paper that had been filed into the court case, but not as exhibits, just into the court case, which, as it turns out, doesn't mean anything because all the evidence has to be in the exhibits, and they weren't ever put in the exhibit file. And now we're going to try to put them in there. That they're not using the form that was approved by the Supreme Court to be used. And so most states have some kind of uniform traffic citation, ticket, whatever you call it. And that's what they're supposed to use, and they've altered it, and they didn't tell anybody, and, so they're not using the right form. Because the idea is for it never to be filed as a criminal matter anyways. There's no money in it. They want to take it through a simulated legal process in a civil court, and because you signed a piece of paper, and now they have a lien against your property. That's you and your body. Your property and your body. Your personal property and your real property. Take judicial notice that I, Rosita Strauskavine, have been falsely arrested, falsely imprisoned. My personal property has been extorted. See Exhibits D and E. And my liberty seized by organized criminal enterprise in violation of Illinois law, federal law, the international law, such as American Declaration of Rights and Duties of Man, Chapter 1, and the enforced disappearance of my proper person in violation of the International Criminal Court's Rome Statute, Part 2, Article 7, Crimes Against Humanity. I invoke these laws in my defense. Take judicial notice that I accept your attorney's oath of office, bind you to it, remind you of a fiduciary duty to uphold the Constitution, therein that you swore to God Almighty to defend. Take judicial notice it would be warring with the Constitution in open court if you failed to protect my life, liberty, pursuit of happiness, and security in my persons. Take judicial notice I invoke equity jurisprudence and ask the court to restore my good name, return me my personal property, undo the Gordian knot of constructive trust separating my natural and legal persons from the immortal living spirit given the name Rosita. Under penalties of perjury provided by... So this is the certificate statement that you're supposed to put on. Every state has a certificate statement that if you don't want to go swear it before a notary or whatever, you just put this on there and it will be treated as such, right? And if somebody wants to... So now somebody needs to challenge that you did it under oath, right? It's between you and God. And then there was another sheet that had her phone number, address, that kind of stuff on. And kind of find out, this is important to know, if you want to be seen in proper person on your court paperwork, you need to put your name, your mailing address, your phone number, and what types of service you will accept. There aren't any paper files anymore. Everything is electronic, and you want to get electronic files. Right? So you tell them you take it by email. You make your own copy. But if you won't take it by email, they don't make hard copies of everything unless somebody asks for it to be made. All right, so we put this on the 8th, and here at the end of the month, boom, there's somebody who's getting arrested. Has to show up to court. Okay, so we're done with that one. All right, so Ray's subpoena. So that went in on the 8th. They had seen it. Ray has to show up on the 13th. By then, they may have an idea that they're going to have to do something with what Roe had just given the chief judge. And so they ended up working a deal out at this hearing where Ray was, where the prosecutor asked for inpatient treatment. And Ray was on the stand or was in the room or whatever, and he said, well, I'm still willing to give her outpatient treatment. And, good. Go ahead and do that. So Ray and Roe talked for 2 or 3 hours that day, and Ray had to put some paperwork in afterwards. And next thing we know, Jed's a millionaire. And Roe was having a discharge hearing, and boom, right after that we find out that there's been a criminal complaint put in against the recorder of the county. Okay, so the people of the state of Illinois. People of the state of Illinois. So we're not quite done with Kane County yet, but that's what happened there. Now, let me turn this off again and go grab some. Okay, and this is what that looked like. This is a notice to appear. Again, this is in the Circuit Court for the 16th Judicial Circuit, Kane County, Illinois, in the Criminal Division. This, I don't know if you noticed in this on the subpoena one before that we looked at before, it said misdemeanor and traffic. This one don't say that. This just says Criminal Division. Because really, it'd be a felony what they were involved in. And now it's gone to a gen number. And this was like the original charging instrument on the very first piece of paper that Roe got. It had gen number 13. Actually, I don't know if it had gen number 13CM3431. But it did have a gen number. I do believe that's what it was. I'd have to go watch my prior video. And this is to, notice to appear, to Sandy Wegman. Please contact ASA, which is the Assistant State's Attorney, upon receipt of this notice. Take notice on Wednesday, March 18th, or soon thereafter as counsel may be heard, we shall appear before Her Honor Judge Morgan or such other judge as may be sitting in her place in courtroom KBC, usually occupied by her, in the Kane County Branch Court, with the address then and there, to participate in a bench trial, at which time and place you must appear. 1245, she needs to appear for a bench trial with her counsel, who's the state's attorney, because the state's attorney represents the members of the elected officers of the county. I think all county officials as far as that goes, but they represent Kane County basically, and she's an officer of Kane County. Right, because the real governmental one is County of Kane, but there's a thing called Kane County that all these people are part of, and right, that's what she's like the state's attorney for Kane County, right? So the prosecutor's office is the counsel for her, and she's been called to court, so they must have got served the arrest warrant. Right, I mean, because they're her agent, basically. So just trying to think of, well, how would they have done the service? Okay, well, they would have served basically themselves and then just sent a notice to Sandy that she needs to appear in court, and she must appear. And so, yeah, she has to appear in court. And looks pretty much legit. So, one of the other things was they had to give, in all this stuff they've had to do here, they had to back themselves out of where they were at one point, and that put them back to prior to a particular increase in her bond for not appearing, and this must have been to do with her arrest or something like that. It had to be what it was. So anyways, they had to cut her a check for $525. And this will blow you away. Before we look at the check, let's look at the envelope. So first of all, this is just one piece of paper, trifold. It's an envelope, a check, and a receipt, all in one. And on the front, look at how they had her address with this 60175 way over here. Well, that's because that isn't Rose's address. It may be Staskovine Rosita's address, zip code, but it isn't Rose. And so they put it far enough away because so that the machine wouldn't see it, and then it would have to be hand sorted, and somebody would say, okay, well, it's 1903 Rita Avenue, right? They would know where it is. They'd look it up and then scan it and send it to the right address. See, because 60175 really shouldn't be way over there. It should be right up over here. And so this check was supposed to have been sent on the 21st. That's when they said I think they did the check. And it didn't mail till like the 3rd of February. Return service requested, whatever that means. But this right here is, 18 USC 1341, 1342. Fraud and swindles and using the mail for fraud and swindles. Because if this is a check, well, Roe gave him dollars, and when you read this thing, you do not find the word dollars on it anywhere. Where's the dollars? D-O-L-L-A-R-S. It's not set up anything like your check, right? Pause it right now, stop and go get a check, and look at your check. They got the dollar symbol inside the box, and on yours it would be outside the box. $575 would be down here underneath the pay to the order of. And as it turns out, Rose's husband had had a similar check where he had been involved in a motorcycle accident somehow and got some money back from the court. And when he went to cash it, he had to pay him $10 to cash the check. It's like, what's that about? Right here's U.S. Bank way up over here in the upper right-hand corner. On yours, it's down here in the lower left-hand corner. This isn't the proper stuff for routing information and so forth. So I'm going to say that's not a check. I gave them dollars, and they're giving me some counterfeit shit back, right? Because on my check, it says dollars on it. Where's my dollars? And that's what we're going to go find out. Is that Roe's going to go to the bank and find out this is a valid check or not? Or what is it exactly? Because it came from, they're saying it came from U.S. Bank. Well, what is it, U.S. Bank? Refund amount, county circuit clerk. It calls itself a check. So the circuit court of Kane County, and we're going to see that the Kane County is really not a county. So the circuit court of the corporation is involved in mail fraud. Right? They're putting one zip code here, and it's going to another zip code. And I had shown this before that when they first arrested Roe, they had it Staskovine Rosita with 1903 Rita Avenue, St. Charles, Illinois, and 60175, and that's not her zip code. And they refused to change it. So, crazy stuff going on. Okay, 1 second. Okay, I guess what I'm trying to do with this video is I'm just trying to point out different places to find some bits of really strong evidence and then what to try to do with it. I mean, on that mandatory judicial notice, you know, you're going to point out that it's against the, you know, that they're violating the Constitution, or they're violating their oath, or whatever it is, things like that. Real general. You don't need to get too specific. And that the plaintiff isn't the government, right? This is the key. The plaintiff isn't the government. The state of Illinois is the government, not state of Illinois. The United States of America is the government. United States of America is not the government. And United States of America is what is on almost all federal court cases. It's not the United States of America, it's United States of America. And so it's basically some dude playing private attorney general trying to prosecute you for breaking a crime of the United States when a complaint hadn't been brought by anybody to the United States. So, so with that in mind, when I'd already done videos before that, none of these people are properly elected, right? The paperwork isn't right. And so one of the things to do is, well, that would be violation of election laws. And that's a crime. And if a crime's been committed, then we're supposed to do one or two things, it looks like to me. Either you send it to somebody like the presiding judge in the mail, what you see happening, on a form that you've basically certified that you're swearing to by using the certificate words for your state, and he would give it to the prosecutor. Or you need to go find the prosecutor that's over misdemeanors and take your complaint to him, and then he would take it to the judge. One way or the other. But I think, by what we did, we took it to the judge and it ended up in the court case. So, because we're pointing out crimes, and you cannot go and prosecute you can't prosecute a crime. That's the state's job. In fact, one of the things I read about this, it says it right there. It's the state's responsibility to prosecute crimes, and you can't do it. So you need to figure out how to take the complaint to them. Because the only reason me or you should ever be going to court is because we're pointing out a crime. We don't take our brother to court. We'd settle it out of court. We don't do that, right? We don't do that to each other. I'm only going to court to point out that somebody is victimizing somebody else. I'm there to point out the transgression. So, we had seen in something that we read that basically the governor was supposed to issue commissions to certain officers. So excellent. Let's go find these commissions to certain officers. And so we had asked for it from the state's attorney's office on a FOIA, and he sent this qualifications of county officers. He said, please be informed that it's the Secretary of State that issues the certificate of qualification. Well, okay, that's not what the election law says, but we'll just go with it. And so we took this and we sent it to the county, and then we sent it to the Secretary of State and said we'd like to have the information on the commission for each of these officers. Well, then they wanted certain names and so forth, so we gave them like 4 names. Long story short. And then they sent some paperwork to us. And so one of them was supposed to have this qualification sheet. And so I, John A. Cunningham, clerk of Kane County, hereby certify that Donald E. Kramer was duly elected sheriff, yada, 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 that kind of stuff, right? But I don't want to look at these yet. I just wanted to show that you might be able to find a list like this. This came from the Index Department, Secretary of State. This is for Illinois. And it's the qualifications of county officers, right? See if you can find that. So This is what we got from the Secretary of State's office, not that one, this one here. Because they had to send their oath, bond, and qualification certificate or election certificate to the Secretary of State's indexing office. And so part of that had to do with bonds, right? So I want to show you all that to tell you this. Sometimes it's real difficult. Joseph Henry McMahon, also known as Joseph H. McMahon, state's attorney, right? But in his proper person, Joseph Henry McMahon, as principal, and this insurance company, corporation, New Hampshire, hereby surety, are held firmly bound to people of the state of Illinois, county of Kane, comma, care of Kane County public officials. So people of the state of Illinois, county of Kane, is a entity of some kind. There's no commas in here. It's just people of the state of Illinois, county of Kane, comma, care of Kane County public officials. It's not the government, right? It's a company. So Joseph Henry McMahon became, and this insurance company, held and firmly bound unto the people of the state of Illinois, county of Kane, care of Kane County public officials. $5,000 first. The surety may, if it shall so elect, cancel this bond by giving 30-day notice in writing to people of the state of Illinois, county of Kane, comma, care of Kane County public officials. That whole thing is the name of an entity. It's a DBA for somebody, apparently. But it's not the government. So this bond doesn't have anything to do with the government. But let's continue on. Okay, so here's his oath of office now. So now he's using his proper name. In this name, I, Joseph Henry McMahon, in his proper person, is taking an oath. He will discharge the duties of my office of Kane County State Attorney with fidelity, blah, 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 blah. The United States Constitution and the Constitution of the State of Illinois. So if I can't find a constitution called the Constitution of the State of Illinois, then he didn't take one to something that has anything to do with anything. All right, they need to call it what it is. And I don't know if that's the proper name for the Constitution of the State of Illinois or not. Constitution of the State of Illinois. All right, is it called the Constitution of the United States? I can never remember till I go and look at it. But I would go and look at it to say, well, what are you taking an oath to? Something that exists or a fiction? Because if it's to the one that I believe, well then, because of that, you have a constitutional duty to me. But now look, here's a change rider. Now, that's where it gets crazy. Here's a change rider. The principal and surety hereby consent to changing the attached bond as follows. The obligee name and address are changed to the following. People of the state of Illinois, county of Kane, care of Kane County public official, 719, right? So now they added the address. Up until then, it had always been the people of the state of Illinois, county of Kane. All right, so they split it up to, so it looks like it's not, the way they're doing it, but that's the obligee. And so on this change rider, the obligee never accepted. They put a file stamp over it to look like something happened, but that isn't what it asked. No, accepted. This was never accepted. It was approved by the chief judge, but she's not the obligee. The obligee is the people of the state of Illinois. And they didn't accept it, so, again, just another another thing they do where the paper isn't done all the way. They don't finish their paperwork. Another one, bond. Yep. I think that was the main thing I wanted to show in that. Was that they do have paperwork in, so we're going to ask, so we're going to ask the insurance company, Liberty Mutual, and send them a copy of the document, just that one page. As soon as I find it again, the Ryder page, and ask them if this is okay, right? Do you accept this? Do you accept that the obligee accepted the terms? Because this is for Sandy Wegman. And she's the one that's going to be in court in just a few days. 18th of March. She don't have bond. Uh-oh. Uh-oh for people of the state of Illinois, I'd say. Okay. I'll show you a couple more. And the other thing we did was we took the same information, we went back to the county, said FOIA for all the county officers, for whatever papers the county had, they had to do with what they were supposed to do for providing paperwork for these elected officials. And so some of them had to get a certificate of election, and some of them had to get a certificate of qualification, and things like that. So this is supposed to be the certificate of election. So again, this is coming from the records of the county clerk. Certificate of election for Patricia A. Del Santo as the superintendent of schools, but it doesn't have a seal on it. Right? So, certificate of election for the circuit court clerk, no seal. Right? Thomas M. Tom Hartwell. That's not his proper name. And in fact, we found one of them bond papers where it has his middle name on it. So Thomas M. Tom Hartwell isn't really holding an office. Sandy Wegman, county recorder. No seal. Joseph H. McMahon, right? Not the middle name. County State's attorney. What county? Should be Kane County State's attorney. That's what it said on his paperwork. Now it just says County State's attorney, but it doesn't have a seal. This dude's got a little bit of a seal. And that's the county coroner, which is kind of interesting because the county coroner is the guy whose main job is to keep an eye on the county sheriff for the king. And so if there's a conflict of interest with the sheriff, you're supposed to be able to go to the county coroner. He is supposed to be a conservator of the peace. And say, well, the sheriff's department's involved. Right? They got me in this court case over here. They're already involved. But they haven't done it properly. I mean, just think that's somebody else you could go to, possibly. Right now I'm just showing that most of these people, their paperwork isn't right. This guy has a seal. I, John A. Cunningham, Kane County Clerk. John A. Jack Cunningham, 4 County Clerk, was duly elected to the office of 4 County Clerk. What the hell is that? What office is 4 County Clerk? 4 County Treasurer. 4 County Sheriff, right? This isn't a mistake. This is the way they have their forms made. What does it mean to be elected to the office of 4 County Sheriff? So, right, so again, this all looks like election fraud. And you would take election fraud and call it such, call it a crime, say it is, here's the evidence, and take it to whomever and show it to them. And the whomever, I believe to be the state's attorney criminal division, misdemeanor, or the presiding judge of your county, who's supposed to be watching over everything for each county. Not necessarily the circuit, although we did the circuit. You know, at the end of the day, you can send to as many as you want and then put it into your court case. But don't put it in the court case, put it in the evidence file, and then into the court case. Which is back to remember, there's a person called the exhibit clerk, and we want to start asking for the exhibit clerk and looking to see how you put exhibits into the court case. And if you're involved in a court case where there's any kind of traffic ticket or something involved, you want to put that in as the evidence and say that it is not, hasn't been done properly. You'd like the court to take judicial review of the paperwork to see if it's been done properly. You think there's a mistake on it. Well, now they got to look at it judicially. You know, we could call it a writ of certiorari, but at the end of the day, we want the court to look at what's been submitted and make a determination if it's proper. Because apparently the judge isn't seeing any paperwork because there's been nothing put into the evidence file. And the rest of it, you ain't going to do anything about unless you tell them to take judicial notice of what's already in the court file. So, crazy stuff going on. And, like I said, there's a whole bunch of other things that I'll get to in the next video. But I wanted to get some of this out of the way because it's just building up too quick. And so we're going to be pointing out some election stuff. The fact that Kane County, now this is interesting, and this will be part of the next video. Kane County is a vendor for the state. It's using an EIN that's been assigned to the county of Kane. Well, the county of Kane and Kane County aren't the same thing. So, you know, you talk about following the money. So now you're down to the comptroller's office. This all has to do with the comptroller's office, where they're listed as a vendor. And then you look at their paperwork they submit, and they're not checking all the boxes they're supposed to check on the paperwork they put into the comptroller. And so if they were to be treated like any other vendor who doesn't do their paperwork right on a government contract, they usually get rid of them. And so in Old English law, then, the comptroller is playing the part of the exchequer. The treasurer is under the exchequer, so forth and so on. And the exchequer is the auditor. And the auditor has direct access to the who's ever in charge. And the office of this auditor goes back. The comptroller comes from, you know, this is in the history what they're talking about in the comptroller's section. But the comptroller comes from the auditor that went all the way back to the Northwest Ordinance. So now we're back in the territory days, it would seem. So there's lots of stuff going on that isn't correct. The bond paperwork isn't correct. If it doesn't say the people, especially on a federal one, that isn't the government, and so we need to be pointing out. In fact, I'm going to show you one more thing before I go. Something we're trying with a gal that's looking at a little jail time. Hang on a second. All right. This idea here you could use with any federal case, in my opinion, if because if the plaintiff is United States of America, well, that's what the bitch is. The plaintiff isn't the government, and the people that are there aren't there in their official capacity. They're not there as, under the name that's on there, a license to practice law. So now it's just a simulated legal process using color of law, and that's a civil rights violation, and we can go on from there. Now, in this particular case, the sister had a had a court-appointed attorney firm, Swanson and McNamara. And so I wrote this I thought, okay, well, let's go to the appointed counsel first and see if they can go do whatever needs to be done to get undone what's happening. And so this is directed towards Edward William Swanson, who's he's the, what is LLP, Limited Liability Partnership, so he must be one of the main partners. So I, whatever her name is, appearing in proper person, inform Edward William Swanson, an attorney licensed to practice law. Right? So that's the name he's licensed to practice in, Edward William Swanson. If you were to go look that up in California Bar Association, which California and many states, other states like Michigan, are states where it's mandatory to be a member of the bar, because the bar is going to be given the authority to prosecute within their own society. Other ones, it's straight out of the Supreme Court, and it's voluntary to be a member of the bar. But anyways, practice that you and Swanson, the company, are court appointed as my attorney, and I demand you defend my good name. Because Swanson and McNamara is a firm that has been authorized to practice law. So it's just like an attorney. Now it is if they did their paperwork right, which of course they didn't, so it's the unauthorized practice of law because they're acting like they're a law firm that's been authorized to practice law. And they'll give you a piece of paper that shows at one time they may have been, but they aren't anymore. So Edward William Swanson, in your official capacity as an officer of the court, take judicial notice that my fundamental rights and liberties guaranteed by the Constitution and treaty have been violated, and your firm's appointment as my defense counsel establishes your fiduciary duty to me to see that I receive justice, a complete remedy in equity, and that those responsible for the malicious prosecution of my person answer for their crimes. Your express consent to be governed by the Supreme Court and its rules, procedures, summary judgment, and orders compels your compliance. However, if necessary, I will have the Solicitor General of the United States of America, compel compliance as he sees just. The plaintiff in CR 11 blah 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 or other action by reference is not the government of the United States, nor is it a criminal matter. Take judicial notice of the organic laws found in the Articles of Confederation. Article 1, the style of this confederacy shall be the United States of America. The United States of America. Doesn't say that as the plaintiff. It's not the government. Plaintiff, United States of America, is not the government. Hey, I just said that. Proceedings are not in accordance with federal rules of criminal procedure because there's no sworn complaint. Step 3, can't go to 4, 5, 6, 7, 8 till you did 3, and there's no sworn complaint. The attorneys involved are engaged in the unauthorized practice of law, not in their official capacity as an officer of the court. Instead, they have engaged in a simulated legal process using color law in violation of numerous acts of Congress. Those would be the laws of the land. Take judicial notice. It appears that Swanson and McNamara, LLP, has neglected to annually renew its certification as required by the State Bar of California rules, and any protection offered by proper registration is terminated. Partners of Swanson and McNamara, LLP, are jointly and severally for the continued crimes against humanity that I am persecuted by. I should have been liable in there. Damn it, I missed the word liable. Hey, if you guys are McNamara, if you're watching, liable. Severally liable for the continued crimes against humanity that she is prosecuted by. Take judicial notice, Edward William Swanson, if you are unable or unwilling to provide me a complete remedy in equity, including the elimination of all civil disabilities, I am left with no choice but to take my grievance to the gatekeeper of the United States Supreme Court for his help in obtaining a writ of certiorari resulting in superintending control from the highest court in the land. Take judicial notice, Edward William Swanson. I demand justice, and you have 72 hours to provide me documentary evidence of your accomplishment of your duty to defend my good name to this email address. Under penalty of perjury, I declare that I have read the foregoing notice and demand that the facts stated in it are true to the best of my knowledge and belief. Executed on. Yeah, so the idea was we're going to give them 72 hours to show that they're making her court case turn around, or she's supposed to, I think on the 18th of, I think it's the 18th also of March. Self-surrender. So, I don't know how this is going to work, but the idea was, well, there's proper notice. We're going to go to them first. And then I had noticed over the weekend that you can actually email directly to the Chief Judge's chambers in the district court. So I'm going to write something up to him to attach to something like this, and we're going to just email it to his office and see if he does anything with it. And right behind it, we're ready to go to the gatekeeper of the United States Supreme Court to see if he does something with it. And if none of those things work, I don't have any other ideas at the moment. Right? Those were my ideas, and that's what we're going to try next. And the good Lord willing, something will stick, because it does appear they do pay attention to when you tell them to take judicial notice. And here's an interesting thing too. The order from for Roe's discharge hearing said that the chief judge was to supply the court reporter. And when you go on the comptroller's website, they have jurisdiction over court reporters. They got a whole section just on the court reporters on the comptroller's website. So I was saying, well, that's interesting as can be. That must be the court's security being notified. So a lot of wordplay going on. Okay, that's all I had for now. I know it's kind of herky-jerky, but that's the way it is when things are just rolling off the hill at you. Those are the big ones. And I'll try to put a little more emphasis on the ones that seem to mean something in the next videos. So, we'll see you later. Bye.